Most people think about the law only when they have to, when they're signing a contract, fighting a traffic ticket, or serving jury duty. But the truth is, the legal system is one of the most powerful forces shaping a country's culture, freedoms, and daily life. And when it comes to the United States and the United Kingdom, these two countries share a deep legal heritage, but they have grown into very different systems. It's easy to forget that the US legal system was born from the British one. The American Revolution may have cut political ties, but it didn't erase the influence of English common law. Instead, the US adapted, restructured, and in some cases, completely reinvented legal traditions to fit a new nation's needs. Over time, those changes and the ones Britain made on its side of the Atlantic have led to two systems that feel familiar in some ways, yet shockingly different in others. Those differences aren't just for lawyers and judges to worry about. They affect ordinary people every single day. From how you're tried in court, to whether you can own certain weapons, to whether someone can sue you for millions of dollars, the legal environment you live in shapes your sense of safety, fairness, and even freedom. Sometimes the contrasts are subtle, like the role of precedent or the way evidence is presented. Other times, they're huge, like how one country uses written constitutions and the other relies on unwritten traditions. Some of these differences make one system seem more protective of rights. Others highlight how culture influences law as much as law influences culture. In this video, we're going to explore 10 of the most surprising differences between the US and UK legal systems. We'll look at how these rules play out in real life, why they exist, and what they reveal about the values each country holds dear. By the end, you might see both nations and maybe your own through a different lens. Because law isn't just about crime and punishment, it's about the unwritten agreement between a people and their government. And when you compare the US and the UK, you see two different visions of that agreement. Both fascinating, both flawed, and both worth understanding. 1. Written constitution versus unwritten constitution. Perhaps the single most fundamental difference between the US and UK legal systems lies in how each defines the ultimate source of its laws. In the United States, that source is crystal clear: the Constitution. Written in 1787, this document is the nation's supreme law. Every legal question, from civil rights to taxation to presidential powers, is ultimately tied back to the words and intent of this text. It's concise, just over 4,500 words, but its authority is absolute. This written constitution serves as both a legal framework and a symbolic anchor. It's the reference point for courts, the rule book for government, and the rallying cry for citizens. That's unconstitutional isn't just a legal argument in America, it's a moral and political one. And because it's written, everyone, at least in theory, has access to the same foundational rules. The UK's system, on the other hand, has no single written constitution. Instead, it operates under an unwritten constitution, which is actually a collection of laws, traditions, court rulings, and conventions built up over centuries. Some of it is written down in statutes like the Magna Carta or the Human Rights Act. Other parts exist as long-standing practices, ways of doing things that have become accepted as law, even if they were never formally recorded. The absence of a single constitutional document means the UK's legal foundation is more flexible. Parliament can pass new laws that override previous ones without going through the kind of constitutional amendment process the US requires. This can make the system more adaptable but also more vulnerable to sudden change, depending on the political climate. In the US, changing the Constitution is deliberately difficult. It requires supermajority votes in Congress and ratification by 3/4 of the states. That difficulty protects it from being rewritten on a whim, but it can also make it slow to respond to modern challenges. In the UK, the lack of that rigid process means legal shifts can happen much faster, for better or worse. For an American looking at the UK, the idea that a country can operate without a single constitutional text feels almost unthinkable. For a Brit, the American obsession with one 18th century document can feel oddly rigid. This difference is more than academic. It's the foundation that shapes everything else in both legal systems. 2. The role of judges and precedent. Both the US and UK legal systems are rooted in the tradition of common law, meaning past court decisions help shape how future cases are decided. This is the doctrine of precedent, and in both countries, it's a cornerstone of justice. But dig a little deeper, and you'll find the role of judges and precedent plays out differently on each side of the Atlantic. In the United States, precedent is important, but it's not absolute. The principle of stare decisis, Latin for to stand by things decided, means courts generally follow prior rulings. However, the U.S. Supreme Court and even lower courts can overturn precedent if they believe it's wrong or outdated. This has led to landmark reversals over time, like the overturning of Plessy v. Ferguson and Brown versus Board of Education, which reshaped civil rights law. U.S. judges also have a uniquely powerful role when interpreting the Constitution. Because the Constitution is a fixed text, much of the legal debate revolves around how its words apply to modern situations. This gives judges significant influence over public policy, even without being elected officials. It's why judicial appointments, especially to the Supreme Court, are such high-stakes political battles in America. In the UK, the use of precedent is more rigid. Courts are generally bound by earlier decisions from higher courts, and overturning precedent is less common. The UK's highest court, the Supreme Court of the United Kingdom, has the power to depart from precedent, but it does so sparingly. This creates a system where legal outcomes are often more predictable but less subject to rapid change. Another key difference is the way judges are selected. In the U.S., federal judges, including Supreme Court justices, are nominated by the president and confirmed by the Senate, often after intense political debate. Once appointed, they serve for life, barring impeachment. In the UK, judges are appointed through an independent selection process designed to keep politics at arm's length, and they serve until a mandatory retirement age, currently 70. This difference in judicial appointment shapes the public's perception of the courts. In America, judges are often seen as political actors, aligned with liberal or conservative ideologies, because of the way they're chosen. In UK, judges are more often seen as neutral arbiters, even though they too inevitably bring their own perspectives to the bench. In short, while both nations share the common law DNA, the U.S. system gives judges more freedom to reshape the law, while the UK system prioritizes stability and continuity. 3. Jury trials, when and how they're used. Ask most people to picture a trial, and they'll imagine a courtroom with a dozen citizens in a jury box, listening intently as lawyers argue and witnesses testify. That image is almost entirely shaped by American culture, TV shows, movies, and news coverage of high-profile cases. In the United States, jury trials are not only common, they're a constitutional right in many types of cases, both criminal and civil. In criminal cases, the Sixth Amendment guarantees the right to a jury trial, and in civil cases, the Seventh Amendment does the same for certain disputes. This means juries can decide everything from a murder charge to a lawsuit over a defective product. Civil juries in particular are far more common in the US than almost anywhere else in the world. In the UK, jury trials still exist, but they are much more limited in scope. In criminal law, juries are typically reserved for serious offenses such as murder, rape, and armed robbery. Lesser offenses are often tried before a magistrate or a panel of judges without a jury at all. Civil jury trials are now extremely rare in the UK, having been largely phased out in favor of judge-only trials, which are seen as quicker, cheaper, and more consistent. There's also a cultural difference in how juries are perceived. In the US, juries are seen as a cornerstone of democracy, a way for ordinary citizens to check government power and ensure fairness. Americans tend to view the jury system as an essential safeguard, even if it's imperfect. In the UK, while juries are respected, there's less of a belief that they need to be involved in every significant legal dispute. The practical impact of this difference is huge. In the US, high-profile trials often become public spectacles, with juries making decisions that can swing millions or even billions of dollars in damages. In the UK, many of these cases would be decided quietly by a judge without the same level of public drama. This divergence reflects deeper cultural values. In America, the legal system leans towards citizen involvement and the belief that peers should have the final say. In the UK, the system trusts more in trained legal professionals to deliver justice efficiently. 4. Criminal sentencing and prison terms. One of the starkest differences between the US and UK legal systems is how they punish crimes. Even when the offense is the same, the sentence can look dramatically different depending on which side of the Atlantic you're on. In the United States, sentences are often much longer. This is partly due to mandatory minimum sentencing laws, especially for drug-related crimes, and partly due to the tough-on-crime policies that shaped U.S. law in the late 20th century. Life sentences without the possibility of parole are not uncommon, and even non-violent crimes can carry multi-decade prison terms. The U.S. also has three-strikes laws in some states, which impose extremely harsh penalties for repeat offenders. In the UK, sentencing tends to be shorter and more focused on rehabilitation rather than pure punishment. Life sentences exist, but they often come with the possibility of parole after a set period, sometimes 15 to 25 years depending on the crime. Very few prisoners in the UK spend the rest of their lives behind bars without any chance of release. There's also a difference in approach to minor offenses. The UK uses alternatives to incarceration more frequently, such as community service, suspended sentences, or rehabilitation programs. The idea is to reduce reoffending by addressing the root causes of crime, such as addiction or lack of education, rather than simply locking people away. The prison systems themselves reflect this philosophical gap. U.S. prisons, particularly maximum security facilities, can be harsh and overcrowded, with an emphasis on security and control. UK prisons, while far from perfect, often have more access to education, vocational training, and mental health support, at least in theory. This isn't to say one system is universally better. Critics of the US approach argue it creates a cycle of incarceration that's hard to break, while supporters believe strong deterrents are necessary for public safety. Critics of the UK's approach argue that shorter sentences can fail to deliver justice for victims or allow dangerous offenders back into society too quickly. What's undeniable is that the US incarcerates far more people per capita than the UK, one of the highest rates in the world compared to one of the lowest among developed nations. And that difference speaks volumes about each country's philosophy toward crime, punishment, and second chances. 5. The role of lawyers in legal representation. If you've ever watched an American courtroom drama, you might imagine lawyers as charismatic performers, pacing the floor, delivering emotional speeches, and swaying juries with powerful rhetoric. In many ways, that image isn't too far from reality. In the U.S. legal system, lawyers are expected to be strong advocates for their clients, using every legal tool available to win the case. Courtrooms often allow more theatrical presentation, and cross-examinations can be intense, with lawyers challenging witnesses in ways that sometimes resemble verbal duels. The U.S. also has an adversarial structure that gives lawyers significant control over the case. They choose which witnesses to call, what evidence to present, and how to frame the narrative for the judge or jury. This can make trials more dramatic but also more unpredictable. In the UK, the role of lawyers, solicitors, and barristers is more formal and divided. Solicitors typically handle case preparation, client advice, and the paperwork, while barristers specialize in courtroom advocacy. Barristers wear traditional wigs and gowns in many higher courts, reinforcing the sense of formality and tradition. While their cross-examinations can be pointed, the tone is often less theatrical and more restrained than in the US. There's also a cultural difference in how lawyers interact with judges. In the US, lawyers may directly challenge a judge's rulings in the moment, sometimes with heated exchanges. In the UK, while barristers can question a ruling, the process is more deferential, reflecting the deeply ingrained respect for judicial authority in British legal culture. Another notable contrast is the use of legal aid. In the US, public defenders are provided for those who cannot afford a lawyer in criminal cases, but they are often overworked and underfunded, leading to questions about the quality of representation. In the UK, legal aid extends to certain civil matters as well, although funding cuts in recent years have limited access. The UK's system historically aimed to make legal representation more widely available, though it faces its own challenges. Finally, the business side of the profession is different. In the US, lawyers often work on contingency fees for personal injury and other civil cases, meaning they only get paid if they win, taking a percentage of the settlement. This fuels a higher number of lawsuits and a more aggressive legal culture. In the UK, contingency arrangements are less common, and the loser pays rule, where the losing party often covers the winner's legal costs, acts as a deterrent to speculative claims. In short, U.S. lawyers operate in a high-energy, client-driven environment where winning is the central goal, while UK lawyers work within a more tradition-bound framework that values procedure and decorum alongside advocacy. 6. The loser pays rule versus each side pays their own. If you've ever wondered why Americans seem to have so many lawsuits, and why Brits tend to be more cautious about taking legal action, this difference might be the single biggest reason. In the United States, the default rule in most cases is that each party pays their own legal costs, win or lose. That means if you sue someone and lose, you're not generally required to cover their attorney's fees, though there are exceptions. This system lowers the financial risk of going to court and makes it easier for individuals to pursue claims, even against larger, wealthier opponents. But it also opens the door to more speculative lawsuits, since the penalty for losing is often limited to your own legal bills. In the UK, the loser pays principle is the norm. If you bring a case and lose, you're typically responsible for your own legal costs and your opponents. This creates a much stronger disincentive to file a weak or frivolous claim, because the financial consequences can be devastating. It also means that before going to trial, lawyers in the UK often urge clients to settle or explore alternatives to litigation, knowing the stakes are high if the case is lost. This difference affects more than just the volume of lawsuits. It shapes the entire legal culture. In the US, lawsuits are sometimes seen as a tool for negotiation, a way to pressure a settlement. In the UK, they're more of a last resort, pursued only when you're confident in your chances. The impact is also felt in business and professional life. In America, companies budget for a steady stream of legal disputes as part of normal operations. In the UK, the risk of paying the other side's costs means corporate legal teams tend to be more conservative, preferring to resolve disputes behind closed doors when possible. Critics of the US approach say it clogs the courts with unnecessary cases and encourages a sue first, negotiate later mentality. Critics of the UK approach argue that it can put justice out of reach for people with legitimate claims but limited means, since the fear of a huge cost order can be enough to keep them out of court entirely. Ultimately, this single rule changes the psychology of litigation in each country, and it's one of the most surprising cultural shocks for Americans encountering the UK legal system, and vice versa. 7. The death penalty. Few legal differences between the US and UK are as stark or as emotionally charged as the death penalty. It's not just a question of law, it's a question of morality, justice, and the role of the state in taking a human life. In the United States, the death penalty remains legal in many states, though its use has been declining in recent years. As of now, 27 states still have capital punishment on the books, and while executions are not frequent, the legal machinery to impose them remains in place. The crimes eligible for the death penalty are typically the most severe: aggravated murder, acts of terrorism, or killing a police officer. But the fact remains that it is an available punishment in a significant portion of the country. The UK, by contrast, has completely abolished the death penalty. It ended for murder in 1965 in Great Britain and 1973 in Northern Ireland, and for all crimes in 1998. The UK is also a signatory to the European Convention on Human Rights, which prohibits the death penalty in peacetime and, effectively, in all circumstances. For Britons, the very idea of a modern state carrying out an execution feels outdated, even barbaric. This difference reflects deeper cultural and political divides. In the US, debates about capital punishment are tied to broader ideas about deterrence, retribution, and states' rights. Supporters argue that it delivers justice for the most heinous crimes and can prevent future murders. Opponents point to the risk of wrongful convictions, racial disparities, and the lack of evidence that it truly deters crime. In the UK, the conversation is largely closed. The death penalty is viewed as incompatible with modern justice. Public opinion occasionally flares up after particularly brutal crimes, with some calling for its return, but politically and legally, it's a settled matter. The death penalty also creates diplomatic wrinkles between the two countries. For example, the UK may be reluctant to extradite suspects to the US if they could face execution, unless assurances are given that the death penalty will not be sought. For an American visiting the UK, the absence of capital punishment might feel like a gap in justice. For a Brit visiting the US, its presence might feel like a haunting reminder of an older, harsher world. 8. Policing and law enforcement powers. If the courtroom is where laws are interpreted, the street is where they are lived. And here the differences between US and UK law enforcement become clear almost immediately. In the United States, policing is decentralized. Thousands of separate law enforcement agencies operate at the local, county, state, and federal levels, each with its own policies, training standards, and cultures. A small-town sheriff's department in rural Texas may operate very differently from the NYPD or the LAPD, and federal agencies like the FBI have their own jurisdiction and authority. This patchwork system means that the experience of being policed in America can vary wildly depending on where you are. In the UK, policing is more centralized, though still divided into regional forces like the Metropolitan Police in London or Greater Manchester Police. The structure and standards are more consistent nationwide, with oversight from the Home Office. There's a stronger emphasis on uniformity of training, accountability, and procedure. One of the most striking differences is the approach to firearms. In the US, most police officers are armed as a matter of course, reflecting a society where civilian gun ownership is common and where officers may face armed suspects more frequently. In the UK, the vast majority of officers do not carry firearms. Armed units exist, but they are specialized and deployed only in certain situations. This changes not only the visual presence of police, but also the dynamics of everyday encounters. Powers of arrest and stop and search also differ. In the US, police have significant discretion in stopping individuals and conducting searches, though these powers are limited by the Constitution and court rulings. In the UK, stop and search powers are governed by specific legislation and codes of practice, with public and political scrutiny over their use, especially in relation to concerns about discrimination. There's also a cultural divide in the role of police within communities. In the UK, the traditional policing by consent model emphasizes the idea that the legitimacy of the police comes from public approval and cooperation, not sheer force. While U.S. police forces may also talk about community policing, the relationship can be more adversarial in certain areas, shaped by historical tensions, higher levels of violent crime, and the presence of firearms. These differences in policing styles feed back into the legal system itself. In the US, the more aggressive and decentralized approach can result in higher arrest rates, more plea bargains, and a heavier court workload. In the UK, the more centralized and cautious approach aims to reduce unnecessary escalation, though it faces its own criticisms about effectiveness and trust. 9. Legal education and the path to becoming a lawyer. The journey to becoming a lawyer in the US and the UK doesn't just differ. It almost feels like two entirely separate worlds. And those differences shape the type of legal professionals each country produces. In the United States, the path begins with a bachelor's degree in any subject, political science, history, even engineering, followed by 3 years at an accredited law school. There is no undergraduate law degree in the American system. Instead, law school is a postgraduate program culminating in a Juris Doctor, JD. After graduation, aspiring lawyers must pass the bar exam in the state where they wish to practice, a notoriously difficult test that measures both knowledge and stamina. This process means that by the time someone becomes a practicing lawyer in the US, they've usually had at least 7 years of higher education and often significant student debt. The legal profession in America is broad. Graduates can enter criminal law, corporate law, public interest work, or dozens of other specialties. But the emphasis is on producing generalists first, who then specialize through practice. In the UK, the path is more specialized from the start. Aspiring lawyers can study law as their undergraduate degree, an LLB, or take a conversion course, the Graduate Diploma in Law, or GDL, if they studied a different subject. After that, the route diverges depending on whether you want to be a solicitor or a barrister. Solicitors complete the Legal Practice Course, LPC, and a 2-year training contract with a law firm. Barristers undertake the Bar Professional Training Course, BPTC, and then a 1-year pupillage under the supervision of an experienced barrister. The UK system produces lawyers who specialize earlier, with barristers focusing heavily on courtroom advocacy and solicitors handling most client interactions and case preparation. The split means that the role of a UK barrister is more akin to a highly trained courtroom specialist, while US lawyers often handle both trial work and other legal duties. There's also a cultural difference in prestige. In the UK, barristers, especially those in the higher courts, are often seen as the elite of the profession, with centuries of tradition behind them. In the US, trial lawyers can be prestigious too, but corporate attorneys, high-profile litigators, and even celebrity lawyers all share the spotlight. Finally, the cost and accessibility of legal education differ. Both systems can be expensive, but the American route often leads to significantly higher debt loads, influencing career choices. UK students may have lower costs overall, especially if they study law as their first degree, but funding challenges still exist. In short, the US produces lawyers who are trained as adaptable generalists and then specialize in practice, while the UK system funnels future lawyers into distinct tracks early on, preserving a centuries-old division of legal labor. 10. The role of the head of state and separation of powers. The way a nation structures its highest offices says a lot about how it views the law. And in this, the US and UK couldn't be more different. In the United States, the president is both the head of state and the head of government. That means the same person serves as the ceremonial leader of the country and the political leader responsible for running it day to day. The president is elected directly through the electoral college system and wields significant powers under the Constitution, appointing judges, signing or vetoing laws, commanding the armed forces, and leading foreign policy. The separation of powers is central. The executive, legislative, and judicial branches are distinct, each acting as a check on the others. In the UK, these roles are split. The head of state is the monarch, currently King Charles III, whose role is largely ceremonial in modern times. The head of government is the prime minister, who leads the executive branch and is chosen from the elected members of parliament. The monarch technically has certain reserve powers, such as dissolving parliament or appointing the prime minister. But these are exercised only on the advice of the government. In practice, the monarchy is politically neutral and acts as a symbol of continuity and tradition. This difference shapes the way law and politics intersect. In the US, because the president appoints judges and is directly involved in law enforcement through the Department of Justice, political battles over the judiciary are intense. In the UK, judicial appointments are handled independently, and the prime minister has far less direct influence over the courts. The structure also changes the tone of political life. In the US, presidential campaigns are nationwide, high-stakes contests that can reshape the country's political and legal direction for decades. In the UK, general elections focus on party platforms, with the prime minister emerging as the leader of the majority party. The head of state, the monarch, remains above the fray, lending a sense of stability even during political upheaval. Separation of powers is another key contrast. The US keeps its branches of government strictly separate, while the UK system blends the executive and legislative branches, since the prime minister and cabinet are drawn from parliament. This can make it easier for the UK government to pass laws quickly, but it also concentrates political power in the hands of the ruling party. In both countries, the courts act as a vital check, but the nature of that check depends on who holds political power and how they interact with the judiciary. The US system often produces visible clashes between branches, while the UK's operates more through convention, negotiation, and political accountability. When you lay the US and UK legal systems side by side, it's tempting to frame the differences in terms of which one is better. But the truth is far more nuanced and far more human. These aren't just systems of rules, they're reflections of national histories, values, and identities. The United States built its legal framework around a single written constitution, deliberately designed to limit government power and enshrine individual rights. It's a system born from revolution, infused with the belief that the people themselves, through juries, elections, and active citizenship, must guard against tyranny. That's why American courtrooms can feel like arenas, why litigation is so accessible, and why the role of the individual looms so large in the process. The United Kingdom, on the other hand, evolved its system slowly over centuries. It's a tapestry of tradition, precedent, and parliamentary sovereignty. Its unwritten constitution reflects trust in institutions, gradual reform, and the weight of history. That's why UK law is full of ceremonial elements, why Parliament can legislate without constitutional amendment, and why the judiciary is kept at arm's length from political conflict. Some differences are practical. The US leans toward longer prison terms and more jury trials. The UK towards shorter sentences and judge-led proceedings. The US encourages citizen involvement in trials. The UK prizes the expertise of legal professionals. America's each side pays their own rule fosters more lawsuits. Britain's loser pays discourages all but the most confident claims. Other differences are deeply moral. The US still maintains the death penalty in many states. The UK has abolished it entirely. The US arms most of its police officers. The UK does not. These choices are as much about cultural identity as they are about crime statistics. And yet, beneath all the contrasts, both systems share the same core mission: to deliver justice, maintain order, and protect the rights of those they serve. Both face similar challenges: public trust, efficiency, fairness, even if their solutions differ. Perhaps the most important takeaway is that neither system stands still. The US is rethinking mandatory sentencing and criminal justice reform. The UK continues to debate the balance between tradition and modernization. Both are adapting to new realities: cybercrime, globalization, and shifting public expectations. In the end, these differences remind us that law is not just a technical framework, it's a mirror. It reflects what a society believes about fairness, authority, and the role of the individual. The US and UK may speak the same language, share many democratic ideals, and even have legal roots in common law. But their systems show how two nations can grow in such different directions from the same starting point. And maybe that's the deeper insight here. There's no single right way to structure justice. There's only the ongoing work of shaping it to fit a nation's values, while never losing sight of the people it exists to serve. If you understand that, you see these differences not as divides, but as lessons. And lessons, unlike laws, belong to everyone.